Hello and welcome back to Death and Taxes, a private wealth podcast from Burgess Salmon. My name is Edward Hayes and I'm delighted to be joined by my colleague from our tax and trust team, Myra Leung. Myra, it's your first time on the podcast today, so before we get into immigration and all things related to, why don't you give us a quick bit of background on yourself and your practice?
Yeah, sure. Thank you for having me. I am an associate in the private wealth team at Burgess Salmon. I am originally from Hong Kong, so I speak fluent Cantonese and some Mandarin. I am a tax and trust lawyer with a specialism in advising on the interactions between UK tax and immigration law. So, for example, moving to the UK, pre-immigration tax planning, residence, domicile settlement, and naturalisation.
Perfect. Well, no better person then to have on today because the focus is, well, it's all well and good talking about the taxation of high net worth individuals who move to the UK and how they'll be treated once they're here. But obviously that slightly begs the question of, well, how do they come here in the first place? And ever since the investment visa was removed for new applicants back in 2022, obviously for some people that question has become more complicated. So if you're happy, Mara, could you sketch out which are the key immigration routes that high net worth individuals and their families should be considering when they're first thinking about coming to the UK?
Well, I always start with a question, why are you moving to the UK? Because I think the client should choose an immigration route that serves the purpose of their move and not the other way around. So usually they might have some sort of connections with the UK. So we always start with, well, whether they are eligible for citizenship. And there are 5 ways of getting British citizenship. So adoption, birth, by descent, naturalisation or registration. We can talk about them in a bit more detail later. So that's the starting point. Usually they've got a connection with the UK. If they don't qualify for citizenship, then we look at whether they've got previous residence in the UK, which is why a lot of people want to come to the UK because they lived here before, they studied here before, and they want to come back. So we look at whether they are eligible for indefinite leave to remain, which is also known as settlement or permanent residence. If they're not eligible for citizenship or permanent residence, then we look at the visa route, which you talk about, because that's their kind of plan C, so to speak. And the key visa categories that are available, apart from the investor route, which are no longer open to new applicants, are ancestry. So if you have a UK-born grandparent and you are a Commonwealth citizen, then you can come into the UK under the UK ancestry visa route. Or the family route. So if you are a fiance, a married partner, child of a British citizen or someone who's settled here, then you can come under the family route. And then another one is a slightly newer option, is called the innovator founder route. So it's pretty much a combination of the various previous incarnations. So startup, innovator visa, graduate entrepreneur. So they've relabeled it as the innovative founder route for people who's got this new business idea that they want to develop in the UK and setting up a company, etc.
Myra, that is a really helpful start to it. And let's dig into that kind of new visa in a second. But actually, I think one point you said that struck me is that almost our starting point as advisors is in some ways the opposite of, I think, how clients often feel about it. In that we start from, well, could you be a citizen already effectively?
Yep.
Do you not even need a visa? Can we get you in that route? If you're not eligible for citizenship, are you nevertheless eligible for indefinite leave to remain? And again, wouldn't need to go down the visa route. Whereas I think a lot of clients probably start by thinking, right, which visa can I qualify for? And so it's quite, I think, helpful to stress that point, that actually the way we work out whether a client has access to the UK and how they might access the UK is probably in some ways the reverse of how many people think about it when they're coming to this completely fresh.
Yeah, totally, which is why I said the first question I ask is, why are you coming to the UK? So we can get into their background and their intentions a bit more, which tie into the tax piece that we'll talk about in more detail later. So I mentioned the various categories depending on why they want to come to the UK. The other ones are less relevant for high net worth individuals, but I'm going to still mention them anyway. So you've got the study visa, visit visa, or the work visa. Work visa is becoming increasingly important now that the investor visa route is gone, because when you have clients who, for example, senior bankers or if they are senior investors, if they can't qualify for citizenship, indefinite leave to remain, or other visa routes, then a lot of the times they will try to get in through the work visa route because they are already associated with a UK business, or they are planning to set up a UK entity. So that's becoming increasingly popular. Whether that's suitable for everyone, that's a different question.
Thank you. And because lots of people will understand that obviously the concept of citizenship, and many will have come across the idea of indefinite leave to remain. Is it possible to give a really high level summary for clients as to, if you are a high net worth individual and you're looking at this as a blank sheet of paper, thinking, how do I start? If they're trying to work out, am I likely to be able to get citizenship or likely to be able to get indefinite leave to remain, could you list out kind of just a few bullet point criteria? Maybe not everything. I appreciate that it's far more nuanced and we can't go through all of the possible ways in which you may or may not be able to get citizenship or ILR, but could we point clients towards kind of some of the key things that might give them a good idea as to whether that's likely to be an option or not?
So let's say the client has no UK connections whatsoever. So, for example, no UK-born parent or grandparent. Then most people, they would have to hold one type of visa for at least 5 years and be resident in the UK for 5 years before they can get indefinite leave to remain. It's important to point out that residence for immigration is different for residence for tax. So interestingly, under immigration law, you look at absences rather than presence in the UK. So unless you've been outside of the UK for 24 hours, then you don't count that as a day of absence, which is different to the midnight test and the statutory residence test for UK tax purposes. So I mentioned that you have to hold a visa for at least 5 years and be resident in the UK for 5 years. And during those 5 years, you can't be absent from the UK for more than 180 days in any 12-month period. So it's a rolling period calculation, which is slightly different to the previous rules. And clients tend to get caught out on it because they don't think about residence from an immigration perspective because they've had tax advisors elsewhere, for example, previously, or they are not familiar with the most recent rules. So that's the key thing to watch out on, is that they are now stricter with immigration residents before they can get indefinite leave to remain, and provided that you haven't been in breach of like immigration rules, or if you haven't had any like convictions, for example, then a lot of people will qualify for indefinite leave to remain, provided that they've held the same visa for 5 years and they've been immigration resident in the UK for 5 years, if the visa leads to settlement. So apart from visit visa, usually.
And as for citizenship, so ILR, you're only going to be eligible for that, generally speaking, if you've had this period of residence.
Yep.
So it should be quite clear to most people whether that's likely something they consider or not. Those who may not currently have British citizenship but might be eligible for it, what are the, I suppose you outlined at the beginning some of the routes to that, but in terms of things that we see in practice that maybe clients haven't realised they'd be eligible for a citizenship, are there kind of common linking factors there where you see actually clients in this position often haven't clocked that this is an option for them, and we're able to kind of give them the good news there?
So interestingly, I've got one matter on my desk. So sometimes it's obvious. If you were born in the UK, then like a lot of people would qualify for citizenship by birth. Or if you have indefinite leave to remain, you've been here for 5 years, then you stay here for another year, then you get citizenship by naturalization. But we've done two recently. It's actually British citizenship by registration based on historical, legislative and fairness. It sounds a bit odd in the sense that it's not something that's common for high net worth individuals, you would think. But actually, we relied on that because the client had a British connection. So, for example, a UK-born grandparent, but actually citizenship doesn't pass down 2 generations outside of the UK. So we have a lot of clients with UK connections, but a few generations ago rather than the most immediate generation, like, for example, parent. And we relied on it because the clients missed out because of the recent changes to the law whereby previously, if you were a married woman, you couldn't pass on citizenship in the same way if you have a child outside of the UK. So that's quite interesting, and people don't often think about how they could get citizenship. And again, I lead back to my initial question: why do you want to come to the UK? We can usually pick out different ways of obtaining UK immigration status rather than just going for a visa and previously investor visa just because they're high net worth individual. Is about the individual circumstances.
Perfect. Well, and that's, I think, a key message, isn't it? Is that don't discount the citizenship route without thinking about it, and particularly without speaking to a qualified advisor like yourself. You can talk to these slightly more esoteric routes into citizenship, which wouldn't maybe occur to all clients or intermediaries. So thank you for that. So I think we've given people a pretty good understanding of when ILR and when citizenship might be an option. If we go back to someone who can only go down the visa route, and they don't have an existing visa for the UK, and they're starting now with how do I come in, if you could go back through maybe some of those visa options that are most relevant and that we see most frequently for high net worth individuals and their families, and sketch out, again, high level, but what are the key criteria to qualify for those. And then after we've done that, I think it'd be really good to go through some practical tips and traps, because we've all come across instances where actually people thought they were onto something good, and then actually for some either practical or technical reason slightly fell foul of the Home Office's rules.
So as you mentioned, the tier 1 investor route was closed to new applicants only 2 years ago. So we've seen interesting cases in the last 2 years. I would say most people tend to go for a work visa because they're actually doing some sort of work in the UK. For example, as I said, like a senior banker or someone who's starting a business in the UK. So they tend to go for that. Or another option is global talent visa if they are a leader in their field. For example, if you have a significant business experience in the tech sector, then it's a potential route for them. But again, there's only, let's say, for the tech sector, it is not applicable to everybody. So between these two, you can usually find a way for a client who's intending to do some sort of work in the UK. I know we discussed this recently, of people setting up a family office, for example, and trying to sponsor clients through the family office under the work visa route. I would say that it doesn't work for everybody, in the sense that if you weren't planning on setting up a family office in the first place, then it might not be the best visa route for them, because when you apply for a sponsor license for the business, you have to meet certain criteria. The business would usually be up and running. So it's more difficult for, let's say, a high net worth individual to come to the UK, set up a family office, and then getting a sponsor license to have all the documents ready. After that, they get the sponsor license, then they can issue a certificate for, let's say, family members to come to get the work visa. But then you also have the ongoing compliance issues. So it's not just about, getting a sponsor license for the family office or getting the work visa for like the family members to come to work in the UK. You have to make sure that they actually do the work they said that they are intending to do in the application, but also the ongoing compliance. So you have to report to the Home Office of changes, and the family office has to be running. You can't just set up like a shell company and then like not do any actual business. So is a possible option.
So a family could set up a business in the UK, whether it's a family office or other business,
a family business,
and use that to help family members into the UK. But they just be very careful that has genuine substance and is kind of genuinely operating separately to its role of bringing in family members, and that's going to be a long-term solution, which will, I suppose, stand up to scrutiny as and when the Home Office look at it again. Is that right?
Yeah, exactly. It's actually something that we discussed amongst the immigration practitioners. Some advisors are almost selling this as a package. And the more they do that, the more the Home Office will scrutinise this to make it more difficult for people who are genuinely eligible to come under this route in this way to come to the UK. So that's why, again, why they're coming to the UK. Is this the right route for them? I think that's the kind of key question.
Understood. So you've got the for those who are coming to the UK to work, you've got the worker visa basically and the global talent visa as possible options.
Yeah.
For those who are coming to start a business, you mentioned the innovator visa, and I'm aware that's got quite a few different criteria associated with it. Let's just go through the key ones. If people are trying to get a broad idea of is that something that they could be eligible for, if you could just broadly summarise kind of who it's really targeted at.
I guess it's in the name. So they recently changed it to Innovator Founder Visa. So you've got the innovation piece. So to qualify, you have to have a new business idea, and the business idea has to be new, as I said, innovative, viable, and scalable. The key requirement is that you have to get an endorsement from an endorsing body first. So the last time I looked, there were only 4 endorsing bodies. And when they started, they had a really long list of endorsing bodies. But now there are only 4 of them. So you have to approach them and say, look, I've got this innovative idea. Can you endorse me? And then one of these external bodies will assess your application to actually confirm whether or not your business idea meets the criteria before you can even apply to the Home Office for a visa. So it hasn't been that popular since it was introduced, because who are these endorsing bodies and how are they qualified to assess the eligibility of the business idea? That put a lot of people off. That's the first hurdle before you even get to the visa bit.
Understood. And presumably the time lag as well associated with having to go through that process before you even submit an application to the Home Office.
Yeah, so it creates a lot more uncertainties, actually. It's harder for advisors to tell the client whether or not they're likely to get the visa if we don't really know whether the business idea will be approved by one of these endorsing bodies.
Understood. So to quickly recap on the visa options that clients can consider, basically, if you're moving to the UK to work, then the skilled worker visa or the global talent visa may be something to look into. If you're moving to start a business, then technically the innovator founder visa is available to you, but in practice there are several hurdles to kind of jump over to make the most of that. And then if you have any historic family connections to the UK, it's always worth thinking about the ancestry visa as well. Are there any others that we think we should be quickly covering off before we move on to some of the practical matters?
Yes, I wasn't sure whether I wanted to mention this, but I think I should. It's the EU settlement scheme. And the reason why I was hesitant is because the deadline to apply was actually the 30th of June 2021. Although the Home Office are still technically accepting late applications, but they're only for people with reasonable grounds to apply late. I've got one on my desk, and we've helped clients previously to make late applications. But the longer you wait, the less likely you'll be eligible. But it's really for EU citizens and the family members who lived in the UK before the 31st of December 2020. Then they can they'll be eligible for the EU settlement scheme. So whenever you have a client with EU connections and previous residents in the UK, it's always good to look at that, because as we said earlier on in the podcast, you want to look at citizenship and indefinite leave to remain first before looking at the visa options, because there are not as many options for high net worth individuals. So EU settlement scheme is another option, but the later you apply, the less likely you get.
Time is running out.
Yes, exactly.
Absolutely. Okay, Myra, thank you. I think that's a fantastic summary of how people might be able to move to the UK and be eligible to remain here. I think in terms of the practicalities, are there any kind of tips or traps that you've seen people either fail to take advantage of or fall into that you'd like to speak to listeners about?
I guess I have 2 tips and 1 trap. So starting with the tips, the first one is actually knowing when and why to engage an immigration advisor or lawyer. I'm not selling myself short here, but a lot of people make applications without having an external advisor or a lawyer. So it's important to know when and why you need one. So for example, if the individual doesn't meet all the requirements, or if they have adverse immigration history in the UK or elsewhere, or if there's a really tight time frame, or if there are any potential grounds for refusal, there's definitely the time to get an immigration advisor. But also if they have wider planning concerns, for example, tax, which we'll move on to later, then it's definitely something to consider. The other tip I've got is actually be organized. It sounds really obvious, but like the preparation and application itself become much more straightforward and less time consuming if the applicant and the dependents can be organized. And a lot of my work is actually project management to make sure that the application is in the best shape possible, to make sure that everything is ready for the Home Office to review and approve.
So those are the positive tips. What are the traps?
The trap is actually providing too much information to the Home Office, and there are several reasons why I say that. Because if you provide too much, then you are at the risk of providing irrelevant information that might detract the caseworker from looking at the actual relevant information. And for example, like mandatory documents might be missed or forgotten if you're focusing on the irrelevant stuff. And the third reason why providing too much is a major trap is that there are greater risk of mistakes and inconsistencies if you provide too much information, because you just don't have the time to look at everything in detail.
And speaking of inconsistencies, I think that's where there's particular value, isn't there? In if you're moving to the UK and you are speaking to the Home Office on one side and HMRC on the other, you need to be very, very careful to ensure that you're being consistent in what you're telling both of those authorities. Because although they do not speak to each other seamlessly, there is overlap there. And anything you record in writing or making a statement or anything like that is basically on the record. And someone who advises a lot on domicile and other statuses, which are heavily influenced by statements people make about their intentions and where they might be. I regularly see that.
Yeah.
And Myra, I'm always enormously appreciative of being able to come and talk to you about, right, from an immigration perspective, what will this mean and what's possible? And we deal with quite a few clients, don't we, where they've had immigration advice from other parties who've said, right, you need to do X, Y, Z over the coming years to kind of guarantee your immigration position. They then come to us for tax advice, and we've said that, well, actually, from a tax perspective, you want to almost be doing the opposite of that. And you're often trying to balance somewhat competing desires there on the immigration and tax side. And obviously we've worked a lot together on matters with both immigration and tax. Have you seen anything you'd like to kind of pass on to people in terms of what are the most important points from your perspective when you're dealing with that crossover?
I think there are two key points. One, you mentioned that the authorities don't always talk seamlessly with each other, but they do talk with, for example, the increasing reporting obligations, for example, like worldwide, not just within the UK. We had a few cases in the UK, we don't have time to go into detail, whereby the applicants were overstating their income and earnings for immigration purposes to show that they meet the financial requirements. But for some reasons on the tax return, the figure of their income and earnings were much lower than what they submit to the Home Office, presumably trying to pay less tax, and they got into trouble. And like the authorities are well aware of this now because of these cases. That's one thing. The other thing, as you said, is intention. We had one whereby the applicant said that she couldn't live anywhere else apart from the UK for immigration purposes in her previous application before she instructed us. At the same time, she was coming to us for non-dom advice, trying to claim that she was non-domicile with no intention to make the UK her permanent home. Now, the two weren't compatible, so we had to manage her application very carefully, and that was tricky, but it's also what I really enjoy doing, the interaction between UK tax and immigration law.
And I suppose helping clients, we do this on the tax side as well, and it's always clients sometimes have an understanding of what they think they need to say to get a good outcome, and actually helping them understand often that no, you just need to say what's accurate in the right way, and that's kind of the best way forward. Well, thank you, Myra. That has been enormously helpful. I think to quickly sum up for the listeners, you when you're looking at moving to the UK, Don't just look at visa options. Also, do look at the possibility of claiming citizenship and or already being eligible for indefinite leave to remain. When you're looking at those visa options, you have now, I think it's fair to say, fewer options available than there were in previous years, but they are absolutely things worth exploring, and we can help guide people through that. And then when you're going through the process of applying, once you've kind of worked out your route into the UK, do be very careful as to exactly what you're saying to whom and in what level of detail, because once you said something, you can't take it back, and you need to be very careful in how you interact with the authorities in the UK to make sure you're basically painting the best picture possible. The private wealth team here at Burgess Salmon obviously has a wealth of experience advising individuals and families with their immigration and tax planning needs. And Myra is a perfect person to talk to on that front. But I'll say now, thank you very much for listening to this episode of Death and Taxes, the private wealth podcast from Burgess Salmon. You can listen to our previous episodes and get in touch with the team at burgess-salmon.com or on our LinkedIn page. Don't forget to subscribe to stay up to date with our latest podcasts, and we look forward to speaking to you again. Thank you very much.